2024 at 5:38 p.m. This is a meeting of the Communication and Policy Committee of the Concord School Board. I am Karen Meeker, the chair. With me tonight is Liz Boucher and Jim Richards. Also with us tonight is Superintendent Kathleen Murphy and Karen Fisher-Anderson from the district. Tonight we have a rather long agenda, but all relating to the same thing, which is policies that we're seeing for the first time that are related to recent changes at the federal level to Title IX. The majority of the meeting is going to be around reviewing Policy 415, Title IX Sexual Harassment Reporting and Grievance Process. I believe, as Karen will explain shortly, there's been a lot of recent changes effective at the federal level, I think as of August 1st, 2024, as it relates to defined terms, which will be important for us, as well as the process by which someone reports discrimination and that procedure. So we want to make sure that we get it right, that we are following the federal guidelines to the T. And so we're just going to be spending a little bit of time in the weeds tonight. Hopefully everybody got the resource materials from the federal government, had a summary that we sent out, a New Hampshire School Board Association resource document that was sent out, as well as the current policy and changes made for this first round by Karen Fisher-Anderson. We had discussed also maybe looking at what it would look like to have a repeal and replace option rather than going through all the strike-throughs, but it looks like we're looking at strike-throughs tonight by what I'm looking at in the packet. So with that, I'm going to turn it over to Karen for the introduction.
Okie doke. A couple things just before we launch into the actual policy itself. Obviously, as you're reading it, the black, just the regular black print in 415 is consistent with what is in the existing policy. The red is the application from the New Hampshire School Board Association Foundation sample, if you will. And then the yellow are my comments with the red. So just to break that up. I did provide this one piece of paper here that says KFA suggested changes. When I was looking at CARA, and I had seen it before, the primer from the Department of Education, U.S. Department of Education, and in fact I really dug into the actual 34 CFR 106. There were some really good, strong statutory definitions, and so those are provided here. Instead of trying to read them to y'all as the changes to this, I just typed them up, and if you like them, we can insert them. If not, they're there for your perusal. You had given me some homework ahead of time, and so I want to give you some answers up front. The question was, just as you had posed to the group, Kara, about can we rescind and replace? Unfortunately, the answer is no, and the reason is you have your 2020 edition of Title IX, and then you have the rewrite that came out on the 1st of August, 2024. It's not retroactive, okay? The rewrite is not. And so when you look at the law, because you have to have congressional authorization to make something retroactive, what will be dependent on which policy we use is the date and when the event occurred, okay? So anything from 1 August 2024 going forward, we will use the new 2024 edition. Okay. If somebody comes in and reports something that happened prior to August 1st, we are duty bound to use the 2020. And it's a nightmare. A lot of people have thrown their hands up. The research is there, and there's been a lot of complaints. But that is why we need to keep both. Sometimes when you have, I will tell you that the 2020 version had a lot more due process requirements in it. It was stronger. The latest one does not. So I don't know what the reasoning is, but unfortunately we can't just say, hey, we're going to do away with 2020, because again, I had somebody recently that I gave the complaint form to when the event occurred back in 2023. So we have to use the old regs. Okay. So the first answer is we have to maintain both policies. And as your Title IX coordinator, what I would do is look at, okay, when was it reported? Okay, and when did the actual event occur?
Mm-hmm. So 2 questions about that. For our purposes, it sounds like then that we need to update 2 policies. Well, it's the same policy number, but 2 effective dates. So effective prior to August 1st, 2024, and then another policy that is effective August 1st, 2024.
Correct.
Both of those policies need to remain on the books.
Correct.
They will need to be labeled very clearly in our policy. And then the other issue is that because we have to update names and information every year, that actually both policies will need updating on a yearly basis.
Correct.
So we may not necessarily update process, but we do need to update like the informational piece. Would you agree?
I would agree.
Okay. So we're actually going to be looking at policy 415 tonight as effective August 1st, 2024. But then we maybe need to also see a draft of what you consider relevant for the 415 that is relevant prior to August 1st, 2024. Do we need to update any information as it pertains to that policy?
No.
So like
We're
names,
lucky.
numbers, everything's the same?
Correct.
Okay.
Yep, the names will be the same. You just have myself, and then you have John Fabrizio as the 504 ADA coordinator. Those are the only 2 that are listed in 415, so that's easy.
Okay.
The only thing I want to make sure we do is make sure we label the policy so that if you're in the policy book, you know which one you're
Right,
talking about.
right.
So we'll make sure that the title is appropriately
Yeah,
changed.
and I would say not only the title, but I think it should be in the footer, so that every time you turn a page, it's a 30-some page document. So every time you turn a page, it's page 3 of 32, effective August 1st, 2024. So that there can be no confusion about which policy.
I would say on both.
Yes, absolutely. Both of them should have clear titles. Both of them should have effective dates clearly written on every page.
And the prior one would be effective start and end?
Correct.
Yeah, so 20, well, was there anything prior to 2020 that we
I don't
even
know.
need to
No.
acknowledge?
No.
But
Right, effective
is there any
date.
policy that, is there someone would come forth and say, this is in violation of your policy, but it occurred in 2009 or something before the policy was in effect, would that policy be in effect back then?
I'd have to go back and, that's a great question. I'll go back and look at
just-
2020 and see how far back
If
that
we
would
need
go.
to, if we can just put prior to 2024, that's fine, but if
Right.
we need to put a range, then
Yeah.
we should.
That's a great point.
Before they actually did the Title IX policies, they used to use Dear Colleague letters through Office of Civil Rights. And so they didn't give
was
clear
no
guidance.
policy.
It's still not that clear, but now but that was the first
Right. So
really
in
formal.
sort of the iteration that we see it, it was born in 2020, it sounds
Correct.
like.
That was the first policy I ever worked on when I came into the district.
Well, I think that's an interesting question, though. If something happened in 2009,
Well, in this
which
case, you would-
policy are you going to use? Do you use the 2020, or because it didn't happen between 20 and 24?
Right.
So which one do you use? Do you use the old or the new? So I think that's an interesting question. We're going to do a little homework on that.
Okay.
So
Yeah, that just seems
Yeah,
like,
but there was no Title IX policy prior to
Prior
the
to that.
2020. I
Correct.
can tell you, I would have
Right.
worked on it.
But I would have assumed in the last 4 years, if something had come up, if an occurrence had taken place prior to 2020, you still would have acted using the 2020 policy.
correct, the due process rights.
All right.
And prior to 2020, most of the attention was placed on post-secondary education, college, universities. It wasn't until quite recently that K through 12, especially in this last iteration, really came
But
into the
that's
fold.
because the policies on discrimination held. That's what we would use.
Yep.
And it would be a violation of Title IX, it could be a violation of discrimination under Title VI.
Yep.
So that's what we used back then that
Right.
would have
10,
applied.
14 maybe.
Yeah.
So that was the first thing.
Okay,
And-
thank
and
you.
then, yeah, no problem. And then you asked me also to please be clear tonight on what is actually mandated, required by law, and what is extra. And I'll try and do that. There's according to the language, and I went back and looked really carefully, where it said must, I figured that didn't give us any clear lever to say, well, maybe. So there's 5 areas, and I can tell you in advance, or I can point them out as we go.
I think if we're going to dig in, you might as well point them out as you go.
Yeah, I would say
It
as
would
we
be-
go.
yeah.
Perfect. All right. Well, with that said, looking at page 1 of the policy, this starts out consistent with what was in the existing policy and that our vision of the school. And then we actually had put in exactly what Title IX says, from the amendment in 1972, and what it applies to. And the thing to keep in mind is, for Title IX, obviously, if you have sexual harassment, which is a form of discrimination, and it affects access to education, programs, and activities, that's where Title IX comes in. And so that's what the first part of this pertains to. It is not, the thing that is required is that we have our non-discrimination policy put into the policy, which it is on the first page. But as far as those first couple paragraphs, that's how we started the last time, and I thought, consistent. But I bring that to you to see if anybody had any objection to leaving it. There was some, where you get down to that first yellow section, this is the first time where I'd seen in a go-by where they refer to things that are going to happen later in our policy, and I wasn't sure. My advice was I'd get rid of it, but that's up to you all. The recommendation is when it happens, we'll address it there. It sort of foreshadows it, but that's what that first yellow is on my part.
So the page one, the first two paragraphs that are highlighted in yellow are recommendations by the NHSBA.
Correct.
And you are recommending that we do not include.
Correct.
Okay.
Because, all it does is point you to like section 2G ahead and then section 2D as far as definitions go.
Right.
So,
I think it's just more words.
Yes, I agree. I think if I could predict what this committee will likely do, it's going to be to remove any redundancies in
Yep.
language.
Okay.
But why don't we go ahead and see as we move through the document if maybe we end up finding it helpful, or let's just see the document as a whole before we make that decision. Does that sound good?
yes.
Okay, I'll
I
flag
just want to
it.
make sure that that is there, that's all. So as we go through the policy, we want to make sure that this is covered, that's all.
Can you say that
I
again?
want to make sure that
They line up.
highlighted, that they
We're
line
found in
up
that
and that that is,
Yep.
because if it's redundant, then we can remove it, but if it's not, then I don't.
I see what you're saying.
Yeah.
Yep, gotcha.
Okay. So the Roman numeral 1 is the wording for the non-discrimination. And that wording is consistent with primer from, I kept the authorities, so page 3 on the Department of Education go by, and that just basically rolls out what our non-discrimination policy says. Again, as you get to the bottom on page 1, they talk about additional information regarding district non-discrimination policies, as you can read that last part. Again, nice to have, I suppose, is it just forecasts that, hey, we're in compliance, not sure whether you want to keep it there. I had recommended deleting those last two sentences. Okay. We move on into section 2, basically the introduction, general purpose. And again, clear, basically that says, any kind of sexual-based harassment is prohibited, and then retaliation. Again, very just broad sweeping statements about we prohibit, and then we respond to sexual discrimination. It does pull into under A, our student and parent handbook, as part of the other policies that apply. And then it also pulls in, we have an additional policy, and these are all in our legal references. Aside from our 415 sexual harassment policy, we have a 414, and it's still in existence. The difference is it doesn't have the tie to affecting educational access for programs, activities, so on and so forth. So it was a backup sexual harassment policy if we didn't have all of that.
Can you pull 414?
Yep. So,
Because I don't know if I have it in my policy book.
okay. And, basically, again, just the general purpose and overall statement that if, under Part 1, if we suspect, and there's a complaint, and then, a report and then a complaint, we have an obligation to respond promptly and effectively to prevent any kind of, hostile environment.
The sexual harassment. Okay. Yep.
415, or 414, and I believe we also have that repeated as 521.
Do you, because 414 is specific to sexual harassment and maybe leaning on definitions that are no longer applicable because of Title IX updates, do we need to review 414 as well?
I don't believe we do, because 414 is not applicable to Title IX. It's sort of
Oh,
a
they're not
catch-all.
connected. I see,
Yeah.
I see.
They're
You
not
said that.
connected.
I appreciate that.
So you don't have to show one sexual harassment and then go, and it affects your access to these things. You can just show the sexual harassment. So it's another way
So
to
it's
handle
a
it.
totally different investigation process.
Correct.
Reporting process.
Correct.
Is that efficient for you?
That's the way I will be honest to tell you that most students choose to go.
Okay. Got it. Thank you. All right.
So, then B again is the language. Are we good? I didn't read it. Okay,
Yep,
B
that's okay.
just goes forward and talks about, we have a notice of non-discrimination as well, and that's the overlapping policy of 161, okay? That has been updated, you'll have that. And then this language at the very bottom of paragraph C, by locating all non-discrimination resources in one place, where you see that and it's red, again, up to you whether we keep that language in there.
Right. That mirrors language from the previous page.
Correct.
Yeah.
Correct.
Okay.
Application of the policy under C on page 2 just talks about who it refers to, and it can be student on student, student on staff, staff on student, staff on staff. So it applies basically across the district. And again, that's old language, it's in black. The red on page 3,
Right.
first
I'm sorry.
par-
I'm just going to pause real quick.
Yep.
I think that the application of this policy, the first sentence is existing, but then from additionally forward, it's new. So I just want to mark that as red.
Where are you, Kara? I apologize.
Oh, sorry. In C, application of this policy shall apply to all students, employees, and any third party
Yep.
who contracts with the district. That sentence ends activity. In the existing policy, that's where that paragraph ends.
Right.
So
The
the
black.
sentence, additionally,
Okay.
the protections extend to any other person who is participating or attempting to participate in the district's education program or activity at the time of the alleged sexual discrimination. That is not in existing language. So I just want to acknowledge that that is new language.
Okay, so it should be red. Okay. Okay.
Is that me? Sorry.
Okay, moving on to the next paragraph on page 3, again, just a lot of introductory language about telling us that you have to, obviously, it's the context of the behavior and then having to decide whether it falls into the definition of sexual discrimination and sex-based harassment. And then saying, but if you look at the behavior and it's not sexual discrimination prohibited under Title IX, you still have an obligation to address it. Okay, so there's where our 414 comes in. And it can also be handled under 161, which is just the discrimination, and sometimes it can be bullying, but that's what it's saying to us is. Is that confusing, Liz?
Nope. I did just want to make a clarification point that it looks like under the definitions section, the definition is sex discrimination, not sexual discrimination. So I just want to make sure that we're being consistent as we add that term throughout,
Okay.
that it is sex and not sexual.
Under the next paragraph you're talking about?
Just all
Anywhere.
instances where the term sex discrimination has been added, it looks
Yep.
like a few occasions it's been sexual discrimination,
And
so we
some
just
it's
need
been
to
sex.
correct
Yep.
to
And-
match the policy, to match the definition section.
Okay. All right. And I'm trying to think if this might be a good, well, no, we're not at the definition, but that, I do have a
Yes,
comment
I'm
on
sorry,
that, so.
just making a
Okay.
note. Mhm.
Okay, and then obviously the follow-on paragraphs, they've been there. It just says it doesn't confer an additional right to a third party. Volunteers and visitors who engage can be reported to law enforcement if they engage in obviously sex discrimination. We report to law enforcement, DCYF, and any kind of third party under the supervision and control, i.e., let's say consultants. They're subject to termination and restriction from school property and other consequences as appropriate. that's consistent, and that is the way we do things.
Can I take you, I apologize, can I take you back to the new language in red above? KFA recommends deletion of this paragraph as redundant.
Yeah.
But it's red and not highlighted. So is it required or suggested?
This is just suggested, and if you look at section 2A, that's where later on in the policy, that's where I felt that it was redundant, the language,
Okay.
so.
All right, thank you. Sorry, please continue.
Nope.
And if my interrupting is bothering anybody, please tell me. And I will
I'd rather you address it
as we
do
go.
it.
That's
Yes,
what
please,
that's why I was
because
trying to,
Then I can make notes.
okay,
Yeah.
thank you.
Okay, so, the last paragraph before definitions is, obviously, the superintendent has overall responsibility, has to appoint a Title IX coordinator, which she has, and then the name, contact information, responsibilities, not only are they set forth in 415, they're also set forth in 161 and some of the other drafts that we're looking at, and pregnant students, and then special education policy. So she has to make sure that, as you noted earlier, if it changes mid-year, we have to go out and advise people of the change and who it is and how to contact them. As we move on to the definition section, again, first line, it says the definition section, complainant, and that's where this comes in, this little page that I gave you, that I wanted, there's only the two, a lot of the language. I know sometimes we want to take it directly from the statute or from the authority if we can. Complainant stayed the same at the beginning.
Can I stop you right there? Why did we eliminate the defined term for actual knowledge?
It's not in the new, it didn't show up anywhere in the new policy.
Okay. So it needs,
So-
okay.
And it didn't show up in the suggested DOE framework either.
So should it be on here still?
Yes, so
and
we'll
then
just need to
crossed
add
out?
the language and then strike the language. If we're gonna go with the strike add model, anything in the existing policy needs to be seen in the new policy and then stricken as needed. So we'll just add the definition of actual knowledge and then strike it.
Okay.
That way, people reading through this and comparing the policies will be able to
Okay.
go one-to-one.
Which
Gotcha.
I'm more than happy to.
Okay, so
To do
actual
that.
knowledge
Clean up.
and then strike it. Got it. Okay. All right, the next one is complaint, which, complainant and then, well, there you go again, complaint. I didn't add them and then strike them, because you've got complainant, but you didn't have complaint under the old one.
Right, complaint is new.
It's all new, so
Yep,
it doesn't,
so
that's not stricken.
Right, so that makes sense.
Okay.
But
so-
in terms of when you add new language and then strike words, I'm assuming that means you are recommending
Correct.
that, so the language came from somewhere. So complaint,
Came from
Came from-
106.6G of the CFR. I'm
so
sorry.
because the definition came as a federal definition,
Yeah.
you do have some words that you are recommending striking. Is that appropriate, given that we probably need to mirror the federal definition exactly?
Actually, complaint didn't come, I don't have it on my report here as coming from the actual DOE go by. It came from the actual CFR, section 106.
Right.
And so,
Can you just read it real quick?
which the complaint?
Yeah.
I don't have
the
the full
CFR.
CFR in
Of the
front of me.
CFR, yeah.
You know what, do I have the CFR site? I don't think I did bring that one.
I know what you're saying, I agree.
Okay, thank you.
We
So
may be able to pull it up.
all I mean is anytime we're pulling something straight from the CFR,
Yeah.
that we can't really, even, just like with the statute, whenever there's a definition that we don't love or a paragraph that wasn't written well, in our opinion, unfortunately, it also, we can't change it because it needs to mirror the existing definition. So when you have complaint means an oral or written request to the district that objectively can be understood, and you have modified it to
Yeah.
that can objectively be understood. I'm not sure if we're allowed to make that change, just because we want to be as precise as possible in matching the definitions.
Okay.
So I would just say anything that is federal or statutory, any recommended changes will probably be a no. It's a no from me.
Okay.
As they say on reality
So
TV.
word for word, and that's what this was meant to do,
Okay.
so. Okay, so complaint is one that needs to be re-looked at. Okay, got it. Dating violence, is one where, now, both for dating violence and then domestic violence, it says to go ahead and take a look at subparagraph 2B, which is the right one, under sex-based harassment going forward. So we didn't define it twice. And so I'm not sure how you all want to address that, if you want to put it in here as it is appearing. We did have it in, we had dating violence in the old policy.
Right.
So-
So I'm sure, because everybody obviously has done their homework and read this already, a lot has been moved under the sex-based harassment definition.
Correct.
So I think it's perfectly fine to acknowledge that language has moved, and so the definition still exists, it's just living in a different place.
Okay, all right. Days was old language, still there, hasn't changed, and it's consistent with what you're going to see in policy 161 when we talk about discrimination, non-sexual harassment. So that seemed fine. Decision maker, I believe, should be one word. It's funny because in our old one I had it as two, but we'll have to look at that. But again, similar language. The only addition is the complaints of sex discrimination, sex-based harassment. Looking to see if there was any definition. There was not. Determination responsibility. Again, old language with the insertion of some of the new decision maker on each allegation of sex discrimination or sex-based harassment. That's the decision person. It used to be, just as an aside, under 2020 regulation, you couldn't be both the investigator and the person who you couldn't be the decision maker too. You had to have a separation of those duties. Now under the new one, the investigator can be the decision maker. Okay, so that was a big change.
Occasionally, they will use decision maker as two words, but with a hyphen between them.
Okay, so is
That's
there
the way they
a
put it
preference
in,
on how
yeah.
you all want it
That's
to
what
be
you want to
done?
do, but we ought to be
My
consistent.
preference is not to add hyphens.
Okay.
So
Then
whatever.
I'm fine with that.
whatever
We
you
left
guys
it the
want. I
way it
think
is. It's
just-
not one word, Karen.
It's decision maker.
Yeah, it
Okay.
is decision maker.
Okay, good, all right.
No,
All right.
I want you to care about it, Liz. Tell me how you feel about hyphens.
care.
Fine.
Okay.
I was just trying to offer a suggestion to the,
Thank you.
Thank you
Not
for
one
that.
word.
Sorry, I just laughed
Thank
right into the microphone.
In determination of responsibility, that R stays, right?
Correct.
Thank you.
You don't want it to be determination of responsibility?
Yes.
So it's like, is it substantiated?
Just to be
or
clear.
not?
Yeah,
So-
and I mean that definition is going to need a little bit cleaning up as well, because you're actually replacing some terms in the definition to update it, which means we're getting rid of sexual harassment, but that doesn't appear in the definition as stricken. So we'll go ahead and clean that up as well. We'll just add that language back in so that we can strike it.
Okay.
And then the question I have here under dating violence and domestic violence, do we have to write them out here?
Yeah,
Too.
which I will. I will do
Okay.
that.
So Kara, are you keeping track of what's going to be
Yes.
stricken and brought back in?
Yep.
Okay, thank
yeah,
you.
because if not, I need to make sure.
No,
we
no,
take
I got
that.
you.
No,
I got
okay.
you.
All right, okay.
So essentially what's going to happen
Trying
is,
to-
I'm not going to say it every single time, because I
Got
think
it.
we all understand at this point that if we're
I figured.
modifying the original policy, everything that exists in the current policy needs to be reflected in the draft, and then if we're getting rid of it, we have to strike it. We can't just delete it.
Okay.
So we understand that.
Yeah.
I'm keeping track. I'm
Okay.
more than happy to backfill
Okay.
that in. Is everybody okay with that?
Yes.
Yeah, I'm
Okay.
fine.
Okay, great. All right, well, domestic violence, again, we did the same thing as we did for, we already talked about that one, I think. Yep, sorry about that.
That's okay.
Education program activity is defined. It did add discrimination in there. So,
Sex discrimination.
sex discrimination, correct. Okay.
So it looks
Now,
like.
here's the question.
That's another fill-in that you have to.
Yes, 100%.
But here's the question. We don't define sex discrimination until later on in the definitions. Before that, in the old policy, is it sex or sexual? It's
Well,
sexual.
I think there was sexual harassment.
Yeah, but
And
not
that's been
discrimination.
updated to sex discrimination.
Yeah,
There's
I was gonna
no-
say, in the old policy, there was no
Right.
sexual discrimination, sex
Right.
discrimination.
Right, there was
it just
sexual
had
harassment.
Right.
And now we have sex discrimination and sex-based harassment. So
Right.
we're expanding on
The
sort of those
definitions.
categories. Because of that, I think we actually need to eliminate any reference to sexual harassment. Number one, because it's not covered in Title IX, and number two, we don't want to confuse it in any way with our policy 414 on sexual harassment.
Correct.
So we don't want to accidentally link the two policies if you want them to be isolated.
Yep. And it is not, you're right, is sexual. Sex discrimination, it's not
Sex-based.
sexual discrimination. It wasn't, you're right. And I think they did
Sex discrimination,
a much better job this time, although the principle applied all along, is that sexual harassment is a form of discrimination. There's a lot more emphasis this time on discrimination. And that's, I mean, it was always there, but they separated them better, I thought.
So am I wrong then? Is there a definition underneath within sex-based harassment that includes sexual harassment?
There is,
I don't think so.
I don't think so. Nope, I didn't
Okay.
see one in here.
No,
Great.
No,
Okay,
they
just wanna make sure.
combined.
Like, there's sexual assault, but not sexual harassment. Okay.
Yeah.
just
Okay,
Being clear on the terms. We got it.
I'll try and go. I'm sorry, you guys, it's
No,
just,
it's
it's so
all right.
It's all
frustrating,
right.
it's so
It's a big
confusing.
policy.
It's like, Okay, so the grievance process, or grievance procedure, that is required, that is a mandatory part, remember you asked me? And that includes supportive measures and all the other things that go in there, so that is one of the required areas.
Are these strikes suggestions?
They're my suggestions based on the wordiness that comes up.
But is it a CFR? Is it a definition that is linked to federal or statutory definition?
Grievance procedure, that one. Can't tell you right off, I don't know.
It's okay.
I'll
I'll
look.
find it.
Grievance
Um,
procedure. I should have brought in, does anybody have their laptop? Nope.
I do.
I was gonna say, do you have your laptop? Because if you pull up, I'm sorry, Liz, but if you
No.
pull up 34 CFR section 106.2, that is the definition section. 34 CFR, section 106.2,
Section 106.
should be your
Point two.
definition section, I believe. Hopefully. And
Just
if
gonna look it
not,
up,
I
too.
can do it after the fact.
There are definitions that came up.
It what?
There are definitions.
Good. So is there one there for grievance procedure?
Is there a way to search it or?
Yeah, it should be. It said find definition here.
CD? E, F, G, I see F,
34
I,
CFR.
P. I don't,
I'm looking it up too, but my Wi-Fi
I
is
see
bad.
C.
some of these strikeouts are just simply wordy, right?
Right,
And-
absolutely.
But your position is that we're gonna just take the exact wording from the federal.
Right,
they
exactly.
require
So,
that.
But I
be-
can see why she,
Oh,
Strike
100%.
through
I
it.
mean, we ask you to be as efficient as possible
Yeah.
with your words.
no.
This is not,
yeah. Because
I would accept your
As used in this
recommendations.
policy grievance procedure, you're repeating grievance procedure.
Absolutely.
And it seems
Yeah.
kind of,
it is okay to
I
be
don't-
critical of,
Or
The
was this
feds.
New Hampshire School Board Association
right, and,
recommendation?
because that's the difference,
'Cause I
right? So
don't
we have
see it
things
on
that we
here.
have to do.
right.
There's
No, I
things
know,
that
I
are
know.
recommended by the School Board Association that if they make it into the draft of the policy, and Karen says, School Board Association, you're being way too wordy with this, we're gonna trim it up. And us as a committee can be like, yep, that sounds good, let's.
But not the feds.
But not the feds, so we just have to
Yep.
have sort of a tally of what is required.
Somebody
procedure.
should have worked with them and try to make them a little less wordy.
Oh,
I would
wait till you
love
get to
to
a
do
couple
that.
of the others. So, yeah, I know what you're saying, Kathleen. I know.
When I read it, I never had a problem with it because I was just trying to be more efficient with the definitions, but, I mean,
Yeah.
I'm thinking about a family or a parent or a student who's
Oh,
reading
absolutely.
this, you know, and
Well, and they say you write it to the age level, there's no way. I mean, it's very
Yeah,
complex.
you go ahead.
So,
Well, and I mean, that's definitely something to talk about, which is that, there's, as far as providing notice to families,
Yep.
we don't necessarily have to hand them this policy and say, good luck. I would.
Actually, you do. You have to hand them a copy of the, I'm
But
sorry.
it's okay, but there has to be some added resource that we can provide them that puts things in plain language.
Me.
Yeah, because we do that with, even the federal government provided a summary, to help us understand all of this stuff. The New Hampshire School Board Association provided us a summary so in my mind, it requires explanation. So if
Absolutely.
we provide that to parents and families, then that's us doing our due diligence.
Yeah, because normally if I have something that falls into it, I actually meet with the student and the parent, depending on the age of the student, and I'm required to provide a copy of the actual policy and a complaint form.
Mm-hmm. Yeah.
And then I'm there to help process.
Mm-hmm.
So, but yeah, it is
Okay.
really so I
So
guess
as far as I can tell, the grievance procedure is not a required definition, so we can play with it
okay,
if we want to.
okay, great.
Can I ask a question?
Yep.
Why is complaint capitalized? In that grievance procedure?
Yeah, just needs to be.
Because it had already been defined up above.
Well, then
And
we
I
need
thought
to-
anytime you,
So we only capitalize the ones that have previously been defined?
I think so.
We are not going to capitalize defined terms other than district
Okay.
and superintendent. I think that's where we landed earlier
just
this
seems
year,
too-
right? Because it's so cumbersome.
Okay.
And it's not a contract. If we were talking contract law, absolutely.
Yeah. Okay, well, just so you all know, and I apologize, I did try and stay consistent there, and I capitalized if it was previously defined. So my bust on that one. Moving on to page 5, hostile environment. Again, they did the same thing with hostile environment as they did with the domestic violence, and just referred to it. The pregnancy or related condition. That's another big add-on to this new Title IX is pregnancy gets a lot of attention, rightly so, as one of the areas we have to be very careful about. It's defined in 106.2 of the CFRs and covers all those conditions.
Okay.
So, now one of the things I recommended adding in here that's not on yours as I continue to work this is whether or not you want to add a definition, it's not required, of preponderance of the evidence. Okay, preponderance of the evidence is the burden of proof that you use when you do a Title IX investigation. Okay, it's talked about, I believe it is. It's talked about later on. Schools have to choose between two standards. One is a preponderance of the evidence, which is 51% of the evidence, or more likely than not. That's the wording. Or you can use clear and convincing. We have always used preponderance of the evidence. So I wondered if it would be smart for us to at least define the term.
I would agree. I mean, if you're saying that the district's use in their investigations, sorry, not the district's use, but the district's leaning on clear and convincing evidence rather than preponderance of evidence, is that what you're saying?
No, we do preponderance of the
Preponderance of evidence, sorry, I got that backwards.
That's
Yeah,
fine.
no, that's okay. And it's talked about later on, but it's nowhere defined as to what that means. And
Okay.
it's a legal term.
Then yes.
Was that
I
in the
would say-
recommendations from the New Hampshire School Board Association?
No, that's my recommendation.
To leave it out.
To
Do
put
we-
it in.
To put it
To
in.
to put that
So,
one in.
yeah, so
Put
this
it
one
in.
is actually.
Do we use clear and convincing,
No.
or whatever it is, anywhere?
No, the only standard,
Then I
you
would
can only
agree.
you have to be consistent in whatever standard you elect. And preponderance is the lowest standard, and then there's the clear and convincing. But routinely, in the last edition that we went and we used preponderance of the evidence.
No, I'm fine. It's just that if, I didn't want to use to define one and not define the other if both were used later. But if only one is used, then I'm fine.
Yeah, only one is used.
Yeah, I think we should add it. Anytime
agree.
we can define, if
Mm-hmm.
we're using a term.
Yep. The other one, I apologize for not catching sooner in the C's, is
Oh, the confidential.
the
Confidential.
confidential employee, but that is further defined if you go to page 12 of 32. There's a whole section on here about who constitutes or who has the privilege as a confidential employee. And so, it's not 12 of 32, I gotta find the page. So I didn't know
No,
if.
it's on 12 of 32.
Okay, good, it is.
Confidential employees, any person employed by the district in a
There you go.
position.
And then A, B, C.
Federal
And so
employee.
I wasn't sure, at first I thought, well, we probably ought to define that. We only have a few of them. For example, our school psychologist would be a confidential employee. If we had a doctor on staff, they too would be because of the privilege. Okay, so whether or not you want to define that term early on or just keep it in on page 12 of 32 as who they are and their status and what it means.
Yeah.
I put that out there as the
Well-
thought.
Can we come back to that? I want to see if we never mention confidential employees outside of that section 3, is it really necessary to
Okay.
further define?
And we only have a few of them. School counselors are not confidential employees.
Along consistency lines, what we decide, because on number 2, we say pregnancy and related conditions. Do we define it there similarly? No, we just use that term.
Well, we've defined it in,
Yeah, and I just want to be consistent, if we define it in the if we're not going to define it in the paragraph, it should be defined in the definition.
yep,
And if we define it in a paragraph, and that's the only place it's ever used, then maybe we can use it as not a definition, but in that paragraph.
right, that's,
Okay.
I agree.
Okay, so I mark that as a food for thought.
Okay.
Okay.
Karen,
Yeah.
Do you know what this policy links to in the School Board Association? I was just gonna try to follow along with their
Yes,
recommendations.
ACC, I believe it is. No, hang on. ACA is this one. I can tell you for sure. ACA. Nope, it's ACAC. ACA is Discrimination and Harassment Grievance, and this is Title IX Prohibition, so it's ACAC. I have a
Thank
copy
you.
of it.
Thank you.
Do you
No,
want a
no, no,
hard
I got
copy?
it. No, the
Okay.
digital is totally fine.
Okay.
Thank you.
Yep. Quid pro quo, again, another definition, obviously falls on later on, and we refer to that down the road. So, recipient, we did define recipient in our last, so.
So is quid pro quo crossed out, struck through, or is it there and it's just the definition is, it's defined?
In subparagraph 1 of sex-based harassment, which is,
Just, it's below in this page. It's on
I
the
know,
bottom.
but do we leave the definition quid pro quo, and the definition of quid pro quo is defined in subparagraph 1 of sexual, or do you strike that out and just define it below?
Well, so what we've done so far is anytime a definition is falling within another definition, we've noted it and said, you're gonna see this later. So that's happened for dating violence is defined under
Okay.
sex-based harassment, domestic violence is
Yep.
defined under sex-based harassment. So far, we've just made note of where those definitions
Okay,
live.
but they're still in the definitions.
Yeah. It's just because it's not in alphabetical order, and so somebody needs direction on where to find
Okay,
it,
I'm fine.
essentially.
all right, continuing down, the respondent had some new language added to it here. Alleged to have violated district's prohibition on sex discrimination. Okay, there's the red in there. Retaliation is defined there. It's also on DOE's go by here on page 5, Kara, that handout. And it gave us, I thought it was a tighter definition, and one of the things that we include in ours that I think is important, and we did last time as well, is we gave some examples. So I think as people are reading through, they're like, well, what kind of behavior? Ostracism, threats, intimidation, coercion, anything that would discourage a reasonable person. So up to you, that is not required, the examples, but we did include them last time, and I thought it kind of gave a feel for what we're talking about. Okay. Then we move on to the new definition.
To me, that makes more sense. People understand that.
Well, it's
You know.
transparent, so I think that's important for them. Sex
What
discrimination.
can we say though? I mean,
And not limited
this is
to.
super in the weeds, but
Yeah,
includes,
yeah.
but is not limited to.
Yeah, I would add that in,
Ostracism, threats, intimidation.
because you never know what else could come up.
Yes. Okay. Okay, you're gonna see this next, under retaliation, this wording about, and it shows up later, it really doesn't belong here, probably in the definition section, but we're gonna talk a lot about the reporting requirements, and there's only two people who don't have reporting requirements. One's the alleged victim, okay, and the second one is a confidential employee. So that, whether you wanna keep that in or not.
Does this language exist elsewhere? Or does it need to?
It does, it does, yes.
Okay.
Yep.
So I would say if this is included elsewhere, then yes, we can delete.
Okay.
But let's make sure it is.
Okay. Then you have the definition of sex discrimination, which comes in new in this this edition of 415, sex-based harassment. Now, what I want to point out here, though, is when you look at the go-by that we got from the Department of Education on page 10, that resource that got sent out, small point, but I think it's important, is they actually combine sex-based harassment with sex-based discrimination. They don't separate them as separate definitions, okay? The other thing that's different between our New Hampshire School Board Association go-by, our current policy, and then the DOE policy, is that when you're talking about sexual harassment, there's three kinds. There's your quid pro quo, there's your hostile environment, and then there's your specific offenses, okay, in that order.
In your sex-based harassment.
Correct,
Okay.
in that order. And so, in the New Hampshire Association go-by, for some reason, they switched the order of those in their final draft. They went from quid pro quo to sex-based, to specific offenses, to hostile environment. My recommendation is gonna be in conformity with the DOE go-by in here, that we do it in that order, and that we combine the definitions. That's what I put here.
So you would like to combine the definitions. You would like to put sex discrimination
And sexual harassment together.
and sex-based harassment
Yes.
as so which definition prevails? Which is the primary definition?
The sex discrimination.
Because sex-based harassment
Is
is
a
a form of sex discrimination.
Correct. And if you look at page 10 on number G on that resource, it gives a really great definition, and it makes it less confusing, I think. So,
I think we can consider it,
okay, great.
but because it's already got so many tiers,
Right.
I'm just want to make sure that it's very clear. You know, once you start embedding defined terms within defined terms within defined terms, it's just that much more difficult to track back.
Right.
So I just want to make sure that if we do that it is very clear.
Yeah,
what-
and
what
luckily
we've
the
done.
terms are the same, it's just for some reason the order. I've never seen quid pro quo and then specific offenses, it's always quid pro quo, and the way I teach it too is I do the quid pro quo and then the hostile environment and then the specific offenses. And so all of that language that you're seeing on page 6 of 32, in red, are the new definitions.
Yep.
And again, they're under the 106.2 of the CFR. I made a couple of little changes, and again, if what you're going to see on page 7 of 32 at the very top for hostile environment, I used the language that the school board recommended, and this is one of the big changes. To determine whether you have a hostile environment, you need subjectively and objectively offensive, and is so severe or pervasive. In the previous draft, it had to be severe and pervasive. So again, a little change there, but hostile environment is the change. It's defined here at the top of the page. So again, 106.
So a hostile environment is sex-based conduct?
Yes.
Okay.
Yep. And then again, as you go down under 3, whether a hostile environment, there has to be an analysis done. It's very fact specific, and you look at, the degrees, the type, frequency, duration, the ages. There's a requirement now that, where it occurred, has there been other sex-based harassment in the education program or activities. We now have to consider if there's an IEP and consult. So that definition is there. Now, as you get down on page 7 to behaviors that constitute sex-based harassment, this is old language. It's not required, but it was in our previous go-by. And again,
I'm sorry. I'm so sorry. Can I stop you real quick?
Of course.
Can we go back up to hostile environment?
yep,
I just want to make sure that we're using complainant and recipient correctly. Whether a hostile environment has been created is a fact-specific inquiry that includes consideration of the following: the degree to which the conduct affected the complainant's ability to access the recipient's education program or activity.
right.
A recipient is the school or school district that receives notice of conduct. Okay.
So, but my question here is that we have recipient in here, but where is that coming from? Because in the example, it just says district's education program or activity.
Yeah, because they tailored it to us. We're allowed to tailor it. But recipient is a defined term in our definitions earlier
Right.
on.
So we should use it to add it? I was just thinking less is better. So do we need to add the word recipient or?
Right, recipient's tough because we're defining that term as the person who received notice of a complaint. So you have the complainant and the recipient. And then, but when you say the complainant's ability to access the recipient's education program or activity, it sort of like assigns the role. Boy, oh boy.
I just think it's more simpler than that.
Yeah.
The district's education program or activity, like it's on, that's
That's
the
more-
district's ours.
Yeah,
Right.
District.
Right, because
You almost want to put the district instead of recipient.
Right,
Yeah.
because the
That's
recipient
what I
must
crossed out.
be the person who received notice.
Right.
Whereas that's not necessarily, like, that recipient doesn't own that education program or activity necessarily. It's the district's education program and activity. So I think I agree that I think we probably shouldn't be using the term recipient in this section,
Okay.
just because it's vague at best.
It's confusing because you think of a recipient as a person receiving something. You
Right.
don't think of it as an organization,
Right.
which is what the district
it-
is, right?
But
the
we have it
definition-
defined here.
The
Yeah, we do.
definition is in
And-
line with that, yeah. No, I
Is
know.
the school or school district
Yep.
that receives
Right.
notice.
And we had defined it previously, so that's why I carried it over.
Would you consider, in cases like that, stick to the definition, stick to the use of the word recipient, but maybe put in parentheses, school district, to help I always think about the person reading this.
Right, that,
Yeah.
I mean,
Yeah,
Yeah.
well,
is the
why would
school
you
or
use school
district?
or school district? Isn't a school a part of the school district?
Oh, district, I think you could just say
Is the
district.
school or
So
district
then
that
in
receives
recipient,
notice of
why don't you
conduct
use school and
could
school district?
constitute.
Right. You mean in the definition?
Why
Yeah.
do we need
We did,
recipient?
we did in the last go-by. It says is a school or school district that received notice of.
Yeah, I know. What's the difference between a school and a school district? Isn't a school a subset of the school district?
Yeah,
So do you really need school?
Well, couldn't you have more than one district in a school district?
Right.
But not
And if you were
us.
an SAU with multiple districts, you
Yeah.
would have multiple, right?
Yeah. So
Like
you-
a cooperative, right?
Uh.
Just to confuse it a little bit
Yeah.
more.
Right, because recipient is it part of the CFR?
No. I don't believe it is.
And is it-
Well, wait a
is
minute.
it
It's
even
not coming up on
necessary.
No,
Yeah.
my list.
So we have
Nope.
the
it's
nec-
not anything on the New Hampshire School Board, so it must not be part of the,
Nope.
I think we can definitely come back to it, but my feeling right now is recipient is not the correct term
Okay.
for what we're looking for here, and there's some ambiguity around the school or district.
Where did that come from, Karen, the recipient? Where did that?
It came from our old, it was in our, in our 2020
policy,
draft, but
right.
it is
Yeah.
not in our,
Right.
it was not a recommendation for
That's
2024.
right. Yep.
Right, so it's
Very
in the
confusing.
previous policy as the school or school district that receives notice of conduct that could constitute sexual harassment.
So we would include it, strike it, and maybe make it district?
Yeah,
Just get rid of that definition.
Yeah, I
Get rid of the
Don't use that
definition,
word.
totally.
if we can get rid of it,
Okay.
Yeah,
I'm not sure it
it's
serves a
not here.
purpose. We can certainly revisit it, but as of
Yeah.
right now, it doesn't, I don't think it serves a purpose.
And then
Okay.
in the paragraph that they use, it will just use district.
Yeah,
Mm-hmm.
Okay.
Yeah, makes sense, because it does get confusing.
Okay. So we had left off on the examples on whether you want to include them. I think they're helpful for folks, again, but over to you all. It's not required.
so
Okay.
the examples of behaviors that constitute sex-based harassment may include but are not limited to.
Correct.
Oops. This is one of those things where I would say if we're gonna nest sex-based harassment under sex discrimination, that these would be examples of sex discrimination, not necessarily sex-based harassment.
Yeah.
That's
I
just
think that's a
something,
good-
something
that's
to
a good
know.
way. We have to be consistent,
Mm-hmm.
so.
But I'm fine with the examples. They're all
Okay.
horrifying, so.
Okay.
So we
s-
could
Well,
put
these
this
are-
under the discrimination piece rather than this one. Is that what you're saying, instead of the sex-based harassment, but put it under?
I'm just saying, well, it's coming after hostile environment. So number one, we probably should separate it out from a hostile environment because I think it's a more broad. These
Yeah,
are
I do
just
too.
examples of
Yep.
sex-based harassment. And if we nest it under the definition of sex discrimination, then it should say behaviors that constitute sex discrimination. How many times can I say the word sex? And then we may want to move it underneath the
Yeah.
primary part of the definition.
Okay. All right, moving on, sexual assault. Again, defined further on, same with stalking.
Well,
And
but we-
Kara, under stalking, are we changing harassment to discrimination there too? Let me look at that, stalking.
Well, again, that's if we decide
Yeah.
that we're gonna combine the definitions. I don't know if we've decided it yet.
Okay. Last time we just had stalking, this time, so, so then there's this, sort of the exemptions that, if it occurred outside the United States or we don't have control over both the respondent and the context, so if it's not a school activity, program, so on and so forth, and we don't own the respondent, then it can't be handled under Title IX. Okay. And I gave an example. That one is, you know, whether you want to keep that, of all
So
of
do
them,
we
I
need
care the
that
least
too?
about that one. The ELOs, extended learning opportunities.
It's because we have ELOs, so we're
Yeah.
giving an example specific to our district. Is that
Correct.
what- Is that what this is?
Yep. We also have the distance learning and the alternative instruction programs like homeschooling.
Could be
So-
Second Start.
Right, so what we're
adult.
saying is that those things are
Yeah,
covered.
right.
Okay, I
Right.
just wanna make sure
Yeah,
we're clear that these are not exceptions, these are inclusions.
right. But because we have those things, we better name them.
Yep. So,
Jurisdiction, sorry, I'm just reading it real quick. This does read like an exception.
Yeah, actually, it does read as an exception. It is
Yeah.
this is a,
at the
so if
end,
this
may
happens
not-
in your ELO that's off school property, then it,
May not
Is
be
or
it-
in
subject
another
to this
alternative
policy.
Right, it's
program,
not
then it may
substantive.
not. So, let's say we send kids from CRTC over to Grapponi,
Mm-hmm.
and something occurs over there. We own the student, we don't own the program, and we don't have any jurisdiction over to Grapponi. So, we'd have to look at that carefully, decide whether or
Yeah,
not it
because
falls in there.
it's a school-sponsored event, right? Whatever.
Yeah, but the control is the hard part.
Yeah, we should have an MOU in advance with them that says,
Mm-hmm.
if something happens, this is how we'll handle it.
What if they're on a field trip at the movie theater and something happens in the dark at the movie theater?
By another student,
Yeah,
we'd handle it.
so it's that.
Maybe not under sexual harassment, but we would handle that one. Because we own both the respondent and the complainant, and it's a field trip. So we'd have 3 things there.
But you
problem
won't
is-
wanna, if somebody was on a field trip and they were walking into the movie theater and an individual that happens to be on that public sidewalk does something that would constitute harassment, we have no control over that, and we would,
We call the police.
that would, and that's when you go back to Grapponi,
You'd call the police.
they would be bound under their responsibility of not having a hostile work environment.
Well, and I mean, I think I'm thinking
not sure the legal part of
specifically of
this.
sexual assault, right? Because when we're talking
Assault,
about hostile work
okay.
environment, we're talking about stalking. These are things that happen over long periods of time. But if there is some kind of incident, sex-based harassment, such as sexual assault, which is sort of incident-based, do we need to have this note about what does and doesn't?
Well, I think of the students at Project Search at the hospital. We have students that are at Second Start, and those are all our programs.
Yeah.
That's an interesting question, and
Yeah.
I felt like it was covering those things. But you're right, it could be
It's not an
exceptions
exception.
where we don't have the jurisdiction.
And to go back to your statement, it doesn't
This
have
is
to be over a
weird.
long period of time for a
Right.
hostile work environment, it could be severe.
Right.
Yep.
And that
Which-
could happen once.
Right.
And I mean, that's really that's the matters I'm thinking of, because obviously this would have to, most of these cases have to be pervasive,
Right.
proven,
Right.
consistent.
Right.
But sexual assault is not. It sort of is separate in that way.
So, yeah, and I did
Yeah.
carry that over from the last one, so, think about whether you want to
about that.
continue it.
Yeah, I think, I agree, because this is more confusing than helpful for us, I want to make sure that if we're trying to be clear about something, let's really be clear about it. So let's look at that language again.
Okay?
And
All right,
that language in that paragraph came from the-
Our old
original
policy.
policy, right?
Correct. Yeah,
Well, this Title IX was meant to clean up some of that. So, in some ways, anyway, we'll think about it.
Yeah, thank you.
It may require it to be deleted. Okay.
the supportive measures definition, I recommend we use let's see where it is, the definition that, it's on page 25, on the DOE guidance. It's just, you start getting into some of the word choice. We definitely should define what they are. And I was looking at ours, and I got into this whole thing about fees and no cost versus fees versus cost versus a fee, believe it or not. Hang on a second. So, but they're no cost, non-disciplinary, non-punitive, they're individual services. This is old language. And again, the new language is at no cost to the respondent as appropriate, and then it goes down and it's talked to, we give some specific examples of some of the things that we do as far as supportive measures, 1 through 8 there, to give parents and people an idea of what we're talking about. I do recommend that we keep 1 through 8. These are also defined in the CFR under 106-44G. But definitely no cost. And we have a case right now where we have done all of these things in one case. And we usually do them for the respondent and we do them for the complainant. So,
what Liz is showing me over here is that 106 CFR, 36, I can't even think of it now, 36 CFR 106.2 in the definitions section.
Yep.
Actually defines supportive measures.
Yep.
It's seemingly been abbreviated by the New Hampshire School Board Association, which looks like what we may be modeling our definition after. I think it's probably more appropriate to follow the federal
Yes.
definition.
And they even combine such measures are designed to restore and preserve equal access. They talk about that in their definition, which is our lower one. So I really thought that their definition is better, the CFR one, obviously, or the DOE.
Yeah, because it says without fee or charge, yeah.
And believe it or not-
Words changing.
Yeah, without fee or charge. A fee is a type of a charge, but not all charges are fees.
Okay.
It's ridiculous, but
So can we update our definition to follow the federal definition and then also include the examples?
yes.
Does that sound good to you?
Okay, then we get down to, we're on page 9. This is the stuff that is required again. You have to point out who your Title IX coordinator and contact information, all has to be put in there. I also included after my contact information, I also have a web page. And so I'm recommending, if you want to, we say see webpage at sau8.org, district info, and then you go in there because it has a huge page there with, all the forms, frequently asked questions, Perkins report, all kinds of things. So if you want to include that, I think it's a good asset.
Yeah.
So then this goes on and outlines, I'm an employee of the district, I have to meet the responsibilities as outlined here in the policy. As of 1 July of each year, the superintendent will appoint your Title IX coordinator, making sure that contact information is known. And then I also have to make sure that I monitor the educational program and activities to be sure we don't have any barriers to reporting. And if we do, we have to address those barriers. And then I'm tasked with the educational training. Responsible for students, staff, and other programs or activities are informed on how to contact its confidential employees. Okay, again, so we have another reference to confidential employees before the one later on.
Okay. We'll likely need to define it in the definitions section then.
Okay. Implementation, again, that's language that says, superintendent has a responsibility to do so. And again, we also have to be laid out in the 161, which is the non-discrimination, equal opportunity, which you'll get next time. And then notice of discrimination, non-discrimination, again, I put the website in there. But
So you would like to delete, KFA recommends deletion of the yellow language as redundant, but that's pretty much all of the section F, implementation.
correct.
So you think that section F is unnecessary?
Well, other than the superintendent has ultimate authority. You're going to read about more of the duties later on.
Gotcha. So it would just remain, the superintendent shall have overall responsibility for implementing this policy. The Title IX Notice of Non-Discrimination is located on the homepage at the district website?
Yes.
Okay, that's fine with me.
Can I go back to prior to implementation, section F, that prior paragraph? We added reasonably calculated and struck it out, is that?
And steps reasonably calculated to address
The
such barriers.
third line down, Karen.
Yeah, I'm looking at maybe under Title IX, take steps to address such barriers. I struck it as wordy. That's just me, reasonably calculated.
But legally, there's a difference between doing something that's reasonably calculated to and doing something that succeeds, which is addresses. I think that might be a legal definition you want to leave in there, but I'll defer to somebody who has a law degree, not me.
Okay. Well, I put the site in there, the 1044D1, I can look at it.
Okay.
Would you
I
look
understand
at
you're not wanting to be wordy, but I think on
whatever
some of
reasonably
those, if that's.
calculated means?
Yep, is it a legal term that has to be there? So, okay, got it. All right, making a report.
No, that comes up a lot, when we
Reasonably
think about.
calculated?
Yeah, when you think about some of the investigations that we've had long-term,
Yeah.
I think of one back, with a student in a bus situation, remember?
Mm-hmm.
And that was long drawn out. It was prior to my arrival here, your arrival.
Mm-hmm.
But it was, the district was able to win on the case because they had done all of the reasonably expected
Due diligence.
processes and due diligence to that case. So, I don't think that verbiage is bad in there, Karen, now that I
And
think
I'm
about
looking
it.
at it, it looks like it's used commonly in IEP.
Yeah,
uh,
I just
There's
want,
a reason.
processes.
Okay.
I really feel we were successful because they had done
There's a
that
reason.
kind of work.
Yep. And then I
Right,
also struck
yeah.
shall be because I thought I could just say is
That's
responsible
fine,
for, it's very flowery.
I have a less of a concern over that particular
Yeah.
item.
So,
Yeah, I'm
Okay.
okay with that. I'm okay with that, Karen.
okay. Then you move down to G on page 10, making a report of sex discrimination. And it just makes it very clear. There's two things. One is a report that anybody can make, and then you're going to read later on that only certain people can be complainants. So a lot of this comes out of our old language. I did include, on the paragraph that starts with any person may report sex-based harassment, sex discrimination, whether relating to themselves or another party or about the district's policies or practices. However, if a district employee, other than the alleged harasser, and then I put in there a confidential employee or the alleged victim of self-discrimination receives, just to keep it consistent with who has to report and who doesn't. Those are your two exceptions. I added those in there.
And we have things like this must be from our previous policy, no case later than 24 hours.
Yes.
So do we need to have a time listed? It's not a recommendation by the New Hampshire
No,
School Board
we had just put that
Association?
in there before when we looked at it on what we thought was reasonable.
I prefer not to have any, that holds our hands.
Yep, okay.
I don't know what anyone else thinks, so.
Yeah, let me read it. I'm just trying to
I don't want to make any commitment
digest.
to.
Right. I mean, does the district think that 24 hours has been reasonable for
Well,
them?
when you have a case like that, I mean, you
Without
take
delay.
immediate
Well,
action.
of course you want to take immediate action, but I think it holds our hands, binds our hands legally if we don't make the 24 hours.
Yeah,
Well, that's a,
And there's no requirement that we have to say 24, if there was a requirement that we had to say 24 hours.
Right, there is not.
There isn't.
Not on that one. That's in the case more of like a sexual assault.
yeah.
If it's, I don't
Yeah,
want to
and
say,
that's
more like a
reported
hostile
to
school
the-
environment, it's not
Yeah,
going to be
and that's
as.
reported to the police immediately.
Because they can
so-
get to the evidence
Yeah.
quicker that way, so.
I don't know, I just think of those kinds of cases and the response immediately that it's
Well,
in process.
I agree with you. I
That's-
think we should. I don't want to bind our
Yeah,
hands.
I understand.
well, it's not our hand, you're binding the hand of someone who.
Who has to
So
make
I'm
sure
an
it
employee for this district, I see something on Friday, without delay is sometime next week?
It's supposed to be the next full school day.
Next Monday?
Yeah.
You know, without delay, well, I don't consider that a delay. What is, the 24-hour just clarifies that we consider more than 24 hours a delay, and you should do it before then. I understand your point.
Is there
I just
an-
want to know, where do we want to be on this as far as what are we hoping employees or teachers would do?
Well, and that's what I teach to is 24 hours when I go over this policy, but it does say in no case later than. And that is
Well,
pretty strong language.
that is.
And also failure to report can subject the employee to discipline up to and including
Including
dismissal. I mean,
termination.
if somebody is
Well, that's where
fearful
your-
to report.
That's where your actual knowledge used to come in, is that actual knowledge can be inferred. It was a very, very broad term.
Aren't they legally required to report things,
Right, mandated.
whether or not
anyway.
they're afraid or not?
Yes.
Abuse and neglect, they are. Let's say they know somebody, it's
Okay.
those kinds of things they are. But
Okay.
this is more of a, we really need you to tell us what you know or what you see or what you suspect.
So,
And they're held
in
to
this
that.
case, we hope you report it, but you don't really have to. It's kind of where we're at right now, right? If we're given an exception for someone who's afraid, well, I can be afraid of everything, or various
Right.
people.
Well,
You know,
Or
some people
losing
are-
friendships, or
Well,
losing,
they're reticent about getting involved because they don't want to be involved.
oh, I know. I'm just a little more sensitive to this because I've been here through 20,
Right.
18, 19.
So you're saying that in no case later than 24 hours is appropriate?
I don't think it's unreasonable myself. I'm open to discussion, but I don't necessarily, I'm kind of thinking, what do we expect our employees
We can have expectations.
Mm-hmm.
And of course, I would want someone to report it, immediately, within, minutes if they, right? Like, that's what we'd ideally, I just get concerned about putting anything in policy that binds anyone.
Okay.
Has,
So
in
without
your time here, has that ever
In
been
a
an
time
issue?
frame.
How about the next?
I have no problem
full-
binding people with having to do it.
Oh, with having to do it, but within this.
Has the 24-hour time limit created any issues for you?
No, not yet, not yet.
I mean,
We did modify another policy, and I can't remember which one it was, where we said 24 hours or the next school day, school day, because we thought, what if we go out on Christmas break? Are we now saying the employee has to call off if they're away and say, hey, I need to make a report? So we gave a little bit more on that one and said the next full school day. So 24 hours is a lot
and
different.
for us, we've done so much
Okay.
training on this.
Yeah.
Annual training, see something, say something, report, even if you don't, you don't have to have a lot of evidence, you can have, a sense of it. We've done so much of that teachers are really, all staff, not just teachers, our associates and everyone has been really, even bus drivers, we've had, give us data. I know what you're saying, but my practice here it's been, something we want to take care of immediately.
Yeah. I mean, I think unless the district has a recommendation to say, like, this is cumbersome for us, this is impossible for employees, we need to modify this if it's been working successfully, and you understand that it actually binds you and employees, like,
Yeah.
as long as the understanding is there.
Again, practice, our principals are immediate in their calls. I mean, they call here immediately.
I mean, I'm okay with it. Are you okay with that?
So-
Okay.
Unless we experience something that would throw us off, I would stick with it. I think it makes everyone understand the importance of it.
All right.
Right, and sometimes it's just redirecting the report, like we had a sexual assault. Well, because it was criminal, we made sure CPD was notified right away. And so we're off limits as far as interviewing the kids until, so
Yeah, we don't even do that because they don't want you to do that.
you're trauma informed, they go to
Right.
this child advocacy center, so hopefully.
Okay.
Okay, and then on that middle paragraph, a report of sexual discrimination, anytime, so we're still talking about the report. It can be, this is a person who witnesses it, okay? They can do it by mail, by phone, they can write it on a paper towel, they can come see me, they can do it on see something, say something. It can be verbal, it can be anonymous. We just make it really clear that if it's anonymous, we may not be able to conduct a thorough investigation. But again, we'd rather they say something because sometimes we'll see a pattern,
Right.
okay?
I mean, there's a kind of a half of a sentence in the middle here.
Where?
A report.
Although difficult.
A report of sex discrimination or sex-based harassment may be made at any time, in person, by mail, by telephone, electronic mail, or by any other means that results in the Title IX coordinator receiving the person's verbal or written report, period. Although
difficult to corroborate. I
difficult
think there
to
should have been a
corroborate.
comma.
Comma.
Comma and not a capital. Although difficult to corroborate, and we don't even need that if you don't want it, but,
I don't think it's needed.
okay.
And is this, so this is not,
This whole thing.
right, is this entire paragraph new?
No.
Or is this part of the existing report?
This is the old one. This is all from the
Where
old.
is it?
Only the first sentence and second, or the last sentence are.
Report of sexual
recommended.
harassment. It's under J, I believe. It's on page 10 of 25. The last paragraph in there is, depending on which one you're talking about, but that came
Yep,
right
I
out of
see it
the
now,
old one.
thank you. Liz, can you say that again, please, what you just said?
If this is taken from, it must be taken from our old.
It is.
Our original policy, but the first sentence and the last sentence of this paragraph appear to be in the recommended New Hampshire School Board, just as a side note.
So the first sentence of the first paragraph.
Of this Yeah, of this that you were just talking about. A report
Oh,
of
I see.
sex
I see what you're
discrimination.
And,
And then the last sentence, additionally, the district strongly.
but the middle part is in there because not everybody out there other than us has a district website at www.sau8.org, so
Right.
that's why it's ours.
Right.
Yeah.
Okay. That's fine with me.
I'm okay with that.
Okay. The rest, again, pretty self-explanatory. There's the note on the bottom that if you're under 18, we have additional reporting requirements, and who we call. I will tell you, that is not a well, that part I don't believe is, and I can tell you, I added in our first draft, the 2020, trying to, make it a helpful resource. The right is that we want you to report it to us, but you don't have to. You can go directly to the Office of Civil Rights. And so we provide the information for the Commission for Human Rights here in Concord and also in Boston for Office of Civil Rights. I do have their updated phone numbers here, but that is not required. I just, again, I was trying to be helpful.
So you're saying everything in the note section? is-
Everything from the note down to page 11, all of that, until you get down to staff obligations to report. Those are supposed to be helpful
Resources for.
resources. Here's the CPD number, here's that, because, parents could be panicking. What do we do? What do we do? DCYF, the hospital, the suicide, these are just resources I thought were important.
As long as they don't change, like the suicide prevention lifeline is really 988 now, it's not.
Right, I changed it on mine. You guys don't, I just redid all of the
So it's
numbers
just something that we
yesterday.
have to continually make sure
Yep.
this is updated if we're going.
Right. Could this be like an appropriate appendices?
Could be an
or,
addendum
like a
if that- if you'd rather.
415.1, since, from my understanding, we do that with other policies where, forms, resources, employee lists tend to be at the end in, an adjoining policy.
If it's at the end in an appendix, does it need to come to a board for numbers?
If it's policy, yeah.
Even though it's at the end, it's like, because it would almost be if this was like a supplemental that could always be updated as needed without
Yeah,
having to
instead of
come
I
to the
think if
board.
and correct me if I'm wrong, if we call it a form, it's not actually policy.
Correct.
Right.
So we could call it a form, a resource form.
A resource form.
Yeah.
I mean, that would almost be a preference. We could say additional
Yeah.
information, resource form, because then Karen could update that.
Right, it
with-
could be updated quickly, easily, and it doesn't have to come to committee, and right now, we're on 32 pages for the
Yep.
policy. We're pretty deep in it. I'm not sure
Yeah.
anybody's gonna find that resource
Well, I
in
was
the
just
middle
going to
of
say the
this.
same thing. I'm not sure they'll go
In the
to
middle of this policy.
appendix, but
What, I totally understand the intent, and I'm so glad that we wanna inform our, families of everything they need to know. I think this could probably be better placed.
okay. Okay, staff obligations to report, I wrote in here, it is redundant with G. Under H, we have G, where we just were. Again, we talk about if you're not in every employee who's not a confidential employee is required to notify the Title IX coordinator. And I probably should say, oh no, because the next paragraph there, it talks about the alleged victim. Does not apply to an employee who's personally subjected to sex discrimination. There is the exception though, unless kids are involved. As I have found in my practice, most victims of sexual assault, they'll report when they're ready. We can't say you must report it, obviously, because they have to do that in their own. But if we see that other kids may have witnessed it or something like that, then we would really want the victim to try and come forward. And that's a sensitivity issue we really have to work on in an individual case.
Can I stop you real quick, Karen?
Sure.
I just want to make note of the time.
Yep.
It's 7 o'clock. And then starting on this page in section H, moving forward, everything is new. Pretty much everything is
Correct.
new. Not highlighted,
Right.
but red, which
The whole
means,
thing is,
No.
what's that?
the whole section is,
Right, so I just want to confirm that moving forward, everything that's here is language that has been directed to us through the CFR or statute and not recommendations beyond that?
There are some
sections.
sections that are black.
Conflict of interest?
Yep. And here, because we haven't, let me give you the 5 areas that come out as mandatory. Designation of your coordinator, your non-discrimination policy, which, says, which was on our first page, grievance procedures, and that's all of section 3, the notice of non-discrimination, and then training requirements. Those are the ones that we absolutely have to include.
And, but the language, so, for instance, training requirements.
Yeah.
Does the law say you must have training requirements, and then we fill in what those requirements are? Or is it all laid out for us?
It is all laid out for us.
Okay.
Mm-hmm.
So I
Because
just
I
want to
have my slides that when I teach, I make
Yeah.
sure that I take it right from what they want us to make sure they know about. The grievance processes, who to report to, so on and so forth.
So I will just say, because of the hour, because of like the next section that we're headed into, I would say other than technical comments, there's really, it's more you just letting us know that it's in the policy,
Yep.
that it's required, and we can just move forward. So you don't necessarily have to explain the process, is what I'm saying. You can just say,
That's fine.
this is covering this piece of the federal law, it's in here for a reason.
There were 2, if I may, on page 24 or 32. You're going to get into evidentiary exclusions, and you're probably thinking, what? Why do we have to do that? Believe me, I looked at it and thought, oh, Lord. But I just wanted to give you, and we would never put an explanation in there, but when you look at, for example, privilege is easy under 6A. That's pretty easily. You got your privilege or your confidentiality, and you have to have a waiver. Let's get down to C. That one gets a little much more complicated, and so where you're talking about prior, and I hope we never have to do this, but sometimes you have to get into examples of prior. What does it mean when we're talking about a prior sexual prior sexual relationship or anything like that? So I wanted to just give you it.
I feel like I read, sorry for interrupting, I
Yep.
feel like I read in the summary from the feds that we cannot look into complainants' previous sexual behavior or interests.
I read that too.
I thought it was
trying to
pretty
find that.
explicit.
Actually, you can in some cases. For example, if you look at 24 to 32, I'm looking, okay, page E6. Let's say, suppose you have a complaint that alleges that the respondent sexually assaulted them at a party, okay? And then during the investigation, in this case, the respondent presents evidence that the person who's complaining had a consensual sexual encounter with another individual at the same party around the same time, almost like a mistaken identity. That kind of evidence is permissible. Now, that is so far in the weeds, we would never go there. But when I was reading it, even with my background, I was like, oh my God, this comes back to my law school days of evidence. I hate it. But it's credible and it's relevant. So there are instances where, and then prior sexual activity between the two parties, that it demonstrates a pattern of consensual behavior. Just because you did it before, I'm not saying, doesn't mean that the next time was consensual. But you do have to, you can in certain instances look at that. So
This says we're not.
Right, this says regardless of relevancy. So this is actually.
Where are you? I'm sorry.
I'm just saying the following types of evidence and questions seeking the evidence are impermissible, and it's under that one. So that would be to me that evidence is impermissible.
Right.
So
like the
even though you
the
might be
example
able
you
to do
just
it, on
used.
our policy, you're not.
Well, look at C.
what
Evidence
I'm
that
saying.
relates, unless evidence about the complainant's prior sexual is offered to prove that someone other than the respondent committed the
Well,
alleged conduct.
But
And
where
then
did
later
that come
on,
from?
prior sexual
Where
contact.
did that one come from? That's
The-
in black.
It came from.
So if
It could carry over from our other policy, but it is in. I'll confirm.
I don't, yeah, let's check that.
Check it if that
see
has to
if
be in
that
there.
came out
Okay.
of the federal,
Yeah,
regs.
check to see if that has to be in there.
Yeah. Limited exceptions under Title
hope we
IX
never
where
have to
evidence
deal
of
with it,
prior
but-
sexual conduct can be relevant and admissible. Now, that's nothing that you all would ever, the normal reader, that's going to be up to potentially your investigator or your decision maker.
Right, but this particular topic.
Yep.
Just on a personal level.
Oh, I know.
I just want to make sure that we are very clear in our boundaries in what we consider exceptions to the exclusion.
Right, and that's why I pulled it up, because I thought, when I was reading it, I was like, that's really kind of a hard one to explain, but those are the exceptions. So,
But, yeah, and we just need the citation for where this exception came from.
Yep.
So that we
Yeah.
can say, this is modern, it's up to date, the language matches.
you got it? Okay,
Thank you. Thanks for highlighting that for us.
sure. Sorry to end on a,
No, it's, and we still have 6 more pages.
well, no, I mean, as far as tonight goes. So, all right.
Let me ask the committee, how's everybody doing? Do we want to keep going?
I'm okay.
You good?
I'd like to finish this.
Okay.
Let's go.
You good to go
All right,
for
these
another?
guys, we're making them stay later, but
No, that's all right.
Okay.
Are they good? Okay, good.
A guide's good in there?
Okay. All
Thank,
right.
Okay.
thank you. Thanks, Josh.
So, we are on, is there anything, you're right, Kara, with regard to all the new language, without having to go through and narrate it for you, for those,
Yeah, I would say from page 11 to, like if page 12 is all new, it's all required. Page 13, it's
Yep.
all new, it's all required. Page 14, all new, all required. Page 15, all new, all required. And then it looks like page 16, there is some black text that is
Yeah.
not red, and it's also in bold, so maybe that means that you want to talk about it. So
in the
let's
event that
make
no, it's
sure.
probably- well, three comments on 16. At the very top, coordinator must take such other prompt and effective. I just had effect, it's effective. And I tried to get rid of such other, must take prompt and effective because it was wordy.
Yeah, that's fine.
Under administrative leave, under L, I'll come back to the bold, under our policies for 414 and 521, when we put people on administrative leave, when put employees, it's paid administrative leave. And I think that's important to put in there pursuant to 18931. For kids, if we're going to put them out, that's a risk analysis, safety risk analysis. This pertains mostly, but it is paid administrative leave.
Well, I don't know as we always have to, so I don't know as we want to put that in.
It's on 414.
No
It's-
So
matter
you want to
what.
be in.
it doesn't
would be
say here that it's
inconsistent.
paid.
It doesn't, no.
All it does
I
is
wrote
says that you
I-
have the permission to, that
Right.
you, there's nothing
That's all
precludes
I
you from
want. I
putting
don't
somebody
want to
on
have-
leave.
So
I
you
don't,
want-
I
That's what-
want the
keep it.
ability, if the situation requires, that it
Right,
would be
so I think
unpaid.
that's
Take it
fine.
out. Okay,
What?
so I'll take it out.
Yeah.
on
What are you
this.
taking out?
I had written in here paid.
She was
Yeah,
gonna,
don't
she was
take
gonna
it.
Yeah.
add paid.
Yeah,
Yeah.
I
Don't
don't
add
want
it.
to add
Don't
it.
add it. Okay.
That'll be a
Struck.
decision
I
that needs
struck
to be
it.
made from an
Thank you.
administrative level.
Okay. I don't know why, oh, I know why. I wanted to just make sure I reminded you all, and you probably know this, under L, in that bold, we can do informal resolutions except in the situation if it's staff on student sexual discrimination. It's not a permissible, you can't do it there.
When you say resolution process, do you just mean
Informal
in
resolution.
no event may the district offer or in no event may the district offer or facilitate an informal resolution process
Correct.
to resolve
So you-
allegations that an employee
Yep.
but here's the sexually harassed a student?
Correct. Involved in sexual discrimination. This did come out of it. There's two ways you can go. You can do your formal investigation phase, or up front, both parties, the complainant and the alleged wrongdoer, can agree to go informal. So you can bring in a mediator, an arbitrator. You can do restorative justice practices. The only time you can't employ informal resolution is if it's a staff on student kind of sexual discrimination. So student on student, student on staff, staff on staff, but not staff on student. So,
Got it.
I got it.
Is this
Actually,
in
yeah,
the-
I think I understand
Is this in the
it.
right place? Oh, because it's in the informal
Yeah.
resolution section.
correct.
Gotcha, okay,
So-
yep. But I also think that sexually harassed is not the right term.
Okay.
Allegations that an employee,
Sexually discriminated again,
you're right.
no. Performs, it could be, there was sex-based harassment.
Sex-based harassment, you gotta try to
Yeah.
get that term in there
Yeah.
somewhere, I think.
The employee used
The school board
sex-based
says
harassment
employees
against a
sexually harass
student.
Okay, we're not gonna take that recommendation.
I'm just letting you know that.
Yeah, that's where that comes from. So the
But
school board
we're
is
saying
just,
it's a sexually based harassment.
right, because we have not
Sex-based
used the
harassment.
term sexual harassment
Right.
at all in this policy. It's sex-based discrimination or, sorry, sex-based harassment or sex discrimination. So we just need to be consistent in those terms.
Yep.
And I agree with you. I'm just was confused with
Right.
the black.
Yes,
Okay.
so it
Yeah.
belongs in red.
I think that was,
Red.
yeah. Okay. Any other questions or concerns about the conflict of interest? I did recommend under S, if you wanted to delete it, because Title IX may have a conflict of interest or bias against. Let me see where I have it written as a conflict. J1-3, I said it was a repeat. JK1-3. J1-3. No, that's training. Oh, I crossed it out. On page 15 of 32, on number 3, where it says, may not have a conflict of interest against or bias relative to either a complaint or the respondent. So, it seemed redundant, but it looks like I crossed it out earlier, or we can leave it in here, where it is now
We need one.
under S.
One of them.
One of them.
Yeah, one of them needs to go.
So I see,
Why
I
is
see
it in red?
one of them in 3,
Yeah,
and then where's the other one?
right, on
Under
S.
S,
Yes.
on page 18 of 32,
I see.
under conflict of interest.
The only reason why I like this one was because it was very clear and it stood out, conflict of interest, whereas
Yes.
in the other
Yeah.
one, it's kind of melded into a paragraph.
Yep, I
Well,
mean,
3 is under informal resolution.
Yeah.
right.
I,
And then this
you need to
S
have it.
applies to everything, even if it's not an informal resolution.
That needs to
Well,
be,
that's
that
true.
needs to stay.
Right.
Okay.
Yeah, I like the.
Yeah.
You want to
All right.
stay? Okay.
Sounds good.
It can
With a
stay.
clear header.
All right,
Yeah.
I like that.
all right.
Mm-hmm.
Records and, record keeping, 7 years. Need to-
That goes along with our policy.
Yep, it does.
Couple battery issues, sorry.
Oh, thanks,
We went
Trish.
too long.
I did add in our policy on page 20, where we're talking about the form and the making of the complaint. One of the things we do, it's in red and I said should be black in here, is that the last line, it goes to the equity piece, if a person making the complaint declines, is unable, requires assistance to make the complaint in writing, we'll make sure there's an interpreter, we'll assist in preparing the written complaint. So that's extra to ours, even though
I'm
it's
sorry,
red.
can
Where
you,
is
yeah,
that?
we
It's on
lost your
page
girl.
20 of 32,
And
top
what-
paragraph,
Oh, okay.
last sentence. Should have been black. That came over from our,
The last sentence, if the person making the complaint
Karen,
declines
I thought
is
they
unable.
required that you do that.
they require that I help them fill out a complaint, give them a complaint form and answer any questions, but this takes,
This takes it
absolutely,
a little bit further.
yeah, I mean, I can actually fill
Yeah.
it, and they sign it.
And I'm fine with that. We need to have,
Okay.
Those-
Also, oh, sorry.
we need to have the translation, we need to be able to do that, and especially people with any issues around,
Right, but
ability
the
to-
translation piece isn't in here, is it?
I thought it
We
was
can
in
add-
here.
Yeah, I thought it was earlier, but.
I did.
I mean, we might have skipped over it because we've been,
Yeah.
Moving along, but
Moving along.
translation is important, because, we do have
right,
a
so
lot
let's
of.
make sure translation is
in
included
here,
somewhere.
yeah.
I'll look for it in the
Yeah.
document. Also, just FYI, the word complaint is in this section when it should be complainant. So we just need to fix all this.
The person's making a complaint. Where is that, Kara? The complainant should also know, making a complaint. All complaints, are you talking about in 19?
I'm talking, yes, so form of and making a complaint. that we're talking about complaints, but then oh, never mind.
Okay.
I thought at some point we started talking about the subject being the complainant, but it's all referring to the complaint.
Okay.
Never mind.
One question I have for you at the end of that paragraph that we just talked about, the translation and assistance. I had written in here in ink, I don't know, a complaint form may be found, it's not on yours, and then I put the website under district information, safety compliance, Title IX, under sexual harassment. So they can go, it's listed online. We don't have a complaint form with our policy, but we do have a web page that they can go right to and download.
Can that website page be updated to remove the term sexual harassment and replace it with sex discrimination?
Absolutely.
But I also fully understand that when we mess with links, it
Yeah,
means that
could
links
change.
go dead
No.
elsewhere, so
Be careful.
be careful.
Yeah. Okay. So,
All right.
I think other than that, it lays out the timeframes on page 21 of 32 are a lot quicker on the rewrite in 2024 than they were in 2020.
Fixed decision maker. The 2 words.
Got
Might
it.
as well be consistent, right?
Did we decide what we wanted? Is
Yeah,
it
we
two
said
words?
Two separate words,
Okay.
no
Okay.
hyphen.
With no
With
hyphen.
no hyphen.
That was one of the pieces in this, is quicker responses in terms of the process, right, Karen? Less days.
Correct.
Right, yeah.
Much
Yeah.
less days.
Right.
Yep. So,
Is there a reason why the order is as is?
I
1,
tried to
2,
do it
3.
in the order of the way that it would occur in the process.
Okay, it's just different than New Hampshire.
Yeah,
School Board
like, for
Association, so I
example,
was confused.
I think they have their appeal of dismissal further down,
Yes.
but I'm like, well, if the appeal of the dismissal isn't granted, then all the other things don't apply anyway.
Okay, yeah,
So
I don't
that's
know
why I did it.
that order, that's why I'm asking
Yeah,
you.
no,
That
no
makes
problem.
more sense to do it that way.
No, that's fine.
And we have more, right? So 9, 10, 11, 12, 13 are more than what the timeframes listed in the New Hampshire School Board.
Do they, what don't they include that we have?
We have, well, this is why their order is different. So they have, I'll read, number 1 is evaluation of the complaint.
Yep.
Number 2 is notices and investigation.
Okay.
Number 3 is evidence organization summarization by investigator. 4, evidence review and responses.
Okay.
That was logging, it was typing.
Yeah, they skipped for some reason, he didn't include a lot of the stuff, as I said, the appeal of dismissal, and then,
Evaluation and
evaluation
determination
of
of appeal
complaint,
and
so it might
dismissal.
not even get that far, but,
Evidence review and responses, decision maker evidence, evaluation, appeal of dismissal. Number 7 is 15 days to conduct the appeal of dismissal. 8 is appeal of determination. And then whatever ones we have that are not listed.
Right, written decision by superintendent or designee, appeal of superintendent or designee, school board decision to hear the appeal, board hearing officer decision, and board hearing officer's written decision to parties.
now, just so you all know, it's a small thing, but the written decision by the superintendent or designee on the merit, there's only two reasons you can appeal. One is on the merits, and then the second one is on if it's an extended a suspension or expulsion. So the school board would hear the
Expulsion.
the time frame, whereas you would be the one deciding the merits. So, and
Just
then it
going
can
back
go on
my
to the state hearing board as well.
Previous, if it's not required, do we want to list it in our policy? Because that binds us.
If what's not required?
If 9, 10, 11, 12, 13 are not required,
Right.
that's binding, do we want to have that in our policy? Not to say that it shouldn't follow an order of operations.
Well, I think it's something,
I just want to.
yeah, I mean, up to you all, but again, it lays out the process.
Is it,
Do we need to say days then next to it?
10 days,
is there a collective bargaining agreement requirement with regards to that?
Sorry,
Well,
I
we
haven't
have
left the
obvious-
conversation. I'm
yeah,
texting my
yes.
babysitter.
Our collective
Sorry.
bargaining agreements all have
Yeah.
very specific timelines.
So, that's what I'm just wondering as to.
Yeah.
how they put that
You
in
have
there,
it,
though.
as you know, you hold the hearings. There is
No, there's definite
absolutely,
timelines.
unless, we've been asked to waive things sometimes, but
But,
there was a
but if we
timeline.
put it in, I don't want it, to Liz's point, I don't want it in the policy if it's something that can be changed in a collective bargaining agreement, because then we often have two sets of rules that have to coincide.
Right.
Like, can we just remove it and
Just
then it
remove it.
fluctuates all the time?
Yeah, the CBA doesn't fluctuate, but this can. There's no,
Yes, the CBA's, and if we pass this policy and we change to CBA, then
yeah.
if
we
it's not
could.
written in stone here, then we can go by the CBA.
Right. But I don't know if you want to use the CBA's timeline.
Is theirs tighter, or, I mean, if we have to use the
No.
most restrictive, or else we're in violation of something.
But if there's no restriction.
That's
by
what I'm
those-
saying, I'd rather take the restriction out here if
So
it's
would
not
I.
needed.
So we're not in
Right.
violation of time.
You can set your own procedures as 10
Exactly.
days.
You can set
but
those
that
timelines.
gives you flexibility for, if it's in the policy, it's in the policy.
Well, but if you look at the paragraph after 13, it allows for reasonable extensions on a case-by-case basis for good cause, and I get to decide those, or whoever the Title IX coordinator is, upon a qualifying request or need presented by the party, investigator, decision maker, et cetera. So we have an out. if we-
Right,
as long
that
as we
is in
document
the
it.
recommendation,
Yeah.
but, so, if we have that clause, I don't know why we still have to set days. People might come at us and say, but you have this as
Mm-hmm.
days.
Okay. Is specifically which one, Liz, or are you looking at
Well,
all
I
of
was just
them?
thinking anyone's that's not required, so
Yeah.
if there's times, if there's days that are not required.
Gotcha.
I would say, again, if these are internal turnaround times that you've been using for some time, if you're comfortable with them, if you understand that you are restricting yourself, and that is your recommendation to the board, please do so.
Yep.
But then otherwise, if it's arbitrary, to Liz's point, we don't need it. So I would say maybe come back to us
Yeah.
Okay, on
with a
time frame.
recommendation on timeframes.
Okay. As I recall, yeah, okay, I'll come back. Never mind,
Because again, I
yes.
mean, we're here to review and to assist and to especially keep things in line with sort of our philosophy.
Yep.
But when it's in the weeds and this is something you guys are doing every day, you let us know
Okay,
if this is important to you to have in the document.
Right, I'm just trying to look out for the district. So
Right.
don't want
I
anything
think
binding us.
Liz is making a great point, and I think I've made similar points in the past, which is why hamstring us when we don't have to. You know, so often we're required to put things in our policies that maybe we wouldn't have done ourselves, right? The RSA dictates it, federal law dictates it. Anywhere we have flexibility is a great time to review what we actually want to do. So I appreciate you bringing it up, but just let us know.
okey-doke.
And I will say, I do unfortunately need to leave relatively soon. So, if there is more to be done in this first round, you can keep going without me. Otherwise, I would say we're obviously gonna be seeing a second round of this next time. So we could pick up on complaints, response to complaints.
I think that'll give us a chance to make all the corrections, come back and walk through those corrections, and then finish up the last 5 or 6 pages.
Okay, is
I
that,
think that's a good, you've been at it now for an hour and plus, so hour and a half,
2
hours.
2 hours?
2 hours.
Can I
Is it
also
already?
request, can
Oh
I
my
also
goodness.
request at some point
Yeah.
that we review the weapons and firearms policy? I do feel that that is related to our facilities.
Yeah, we have it, we're ready, I mean, we're ready, but this just kind of jumped in front of us,
Correct.
run in the line, right? Because we made some great progress, you got this finance done, you got facilities, you got the tobacco vaping policy, so we have made some. This kind of jumped ahead of the
It's
line.
hard work,
But
yeah.
we can bring that, did we load that weapons into the?
No, not yet.
No, but you know what I'll do? I will load that one into your folder.
Okay,
All right,
great.
so
Okay.
you can at least look at it,
Great.
all right? And then, I have no problem getting it to you, we've worked on others, but like I said, this one,
Right, I mean, this one
Went
is
to the head of the
necessary.
line.
I'm glad we're getting to it. We're behind.
I felt comfortable
with-
though, Kara,
yeah,
because we
you
had
had
a
the
decent
existing policy,
policy in
100%.
place, so I felt like we were not so, but the next meeting for communication and policy is November 20th. All right? It's hard with so many things going on
Yep, that's
this
okay.
month and into Christmas, but there is another one scheduled for December too. Okay. So,
That's okay. All right,
but we didn't
so
do two.
in sum, I think we have quite a few updates, changes, questions that you guys can answer at the next meeting. We're gonna pick back up on page, what was it?
I did,
We're gonna pick up on page 22 of the document, section
Section
E,
E.
district response to complaints
Yep.
of sex discrimination. And do I have a motion to adjourn?
So moved.
Second.
Moved and seconded, all in favor?
Aye.
It is 7:29, we are adjourned.
Thanks, everybody.
Yep, thank you.
Thank
Hey,
you.
kept it.